Today's the date and time that was originally set for sentencing. I have received and reviewed the recommendation from probation with Ms. Johnson. She has not, we do acknowledge she has not completed the alcohol screening and assessment through Von Schwartz, and she did miss a test on July 1st. I did discuss this with her yesterday on the phone and advised her to go to community corrections as soon as possible to try to test. She informed me, and so did her father, who is here with her today, that she did go to community corrections this morning before court and was there for about 45 minutes, and they said she was unable to test this morning. We are respectfully requesting that the court not remand her at this time and that we adjourn the sentencing out in August to give her the opportunity to complete the alcohol screening and assessment. She is gainfully employed at St. Joe's. She does not want to lose that job. In the alternate, if the court is inclined to remand her in both speaking with Ms. Johnson and her father, our request would be to potentially allow that remand to happen a couple weeks in the future so she can take time off work at St. Joe's so she does not lose that job. Other than that, Your Honor, we respectfully request an adjournment of the sentencing.
And Teresa Claire on behalf of probation. Your Honor, I did communicate with community corrections this morning. She did go over and she wasn't scheduled to do a test today, so she did not test. She did do her download of her scram. I just confirmed with them that there was no violations on the scram. However, she had not reported to them after June 15th. So there was quite a bit of info that they had to download on that. So I do know that there was no violations on the scram. However, probation also wants to point out to the court that this court did direct her back on April 3rd, I believe, and warned her about any further mistesting. So she was given a warning by this court back in April about her remaining compliant with the testing order.
Why?
Why what?
Why'd you miss a test? I mean, I gave you a huge break back in April and just told you, just don't miss the test. You remember that, right?
Yeah.
And then when you pled, why didn't you do your alcohol screening and assessment?
Forgot to print it out.
What?
I said I forgot to print it out.
Oh. They do so much. I mean, I didn't send you the last time. I'll re-refer to defendant to Von Schwartz for completion of her alcohol screening and assessment. Young lady, understand something. If you don't do it, and I don't have that alcohol screening and assessment, the only thing that I can really sentence you to is the maximum time. And I don't want to.
Paper?
What?
The paper?
What?
All the lists on it? What is Von Schwartz?
That's for your alcohol screening and assessment.
Is that somebody I'm supposed to go to? What does that name stand for?
That's somebody that you need to call to set up an appointment so that they can interview you and do an assessment.
Okay.
And Your Honor, my office, I know that the clerk's office sends things out. My office also sent an email to her on June 5th, which gave her the packet and the information for the alcohol assessment in addition to the information to complete the victim's impact.
Need to pay a $75 referral fee. Do you have that?
No.
Adjourner sentenced to August 28, 2024, 9 a.m. Young lady, you are leaving me with no options. And I have a feeling that if you don't follow this, that I'm going to end up sending you for the maximum time. I don't want to do that. I'm going to end up finding you in contempt and sending you. So in this, I'm going to, for the bond violation, I'm going to remand her for 3 days. Washtenaw County Jail for the bond violation. Defendant's remanded. Just go. Is that Dad?
Yes, Your Honor.
Get her back. Dad, hang on one second. Go ahead, take her back. Come on up to the, can you come up to the phone? What's your name, sir?
Tony Johnson.
Okay. Can you help try to get her through
Yes, I will definitely make sure that she does it. She lives with her mom, so I don't kind of know the things that kind of goes on. So I'm just coming to support, and I just was hoping that you didn't take her to jail because
I know.
she need this job so bad.
I know. And I trust me, I did not want to. Miss Polera, can you give to Dad the Von Swartz information and the victim's impact information so that he has it, so that I get where he is, so that he knows what she has to do.
Yes, Your
So
Honor. I do know, I heard him in the hallway, really getting after her for not doing it. So I think that he will.
Well, I don't doubt
If
that.
you stop by my office, or I'll ask them to give you the paper printed out.
Is that in this
It's
building?
right down the hallway.
Okay.
And so I'll tell them you're coming right down.
And,
Okay.
I have the $75 for any fee or whatever that she might have needed to pay. I do have the money, so.
Whose case is this? Yours?
In today's courtroom, we see a case that highlights one of the toughest issues family courts ever face: child support, fairness, and the question of genuine disability. Miss Kirby brings her case before the court, frustrated and determined. She claims that Douglas Kirby, the father of her 8-year-old son Danny, has not paid child support for the last 2 years. According to her, Douglas once paid regularly, $1,000 a month, but suddenly stopped. Now, she wants answers. And as she puts it, she wants to know when he will start paying again. Douglas admits he stopped paying, but his reason is very different. He testifies that he was diagnosed with multiple sclerosis 3 years ago, a serious and progressive illness. Over the course of just 8 months, his health collapsed to the point that he could no longer work. Since then, he says he's been unemployed, surviving on disability and Social Security benefits. To support his testimony, he produces official award letters from the state confirming those benefits. The judge reviews them carefully, and they appear legitimate. But Miss Kirby doesn't believe it. She insists Douglas is exaggerating his condition, that he could work with minimal duties if he chose to. To her, this isn't about disability. It's about avoidance. She even accuses him of being lazy, of wanting to stay home, sleep until noon, and play guitar rather than face adult responsibilities. In her eyes, Douglas is a man hiding behind paperwork while his child suffers. For her, the courtroom is her last chance to hold him accountable. The judge, however, pushes back on her claims. She explains that when someone is officially on disability, the law does not allow the court to order support payments beyond what the person is capable of. Social Security disability checks cannot simply be garnished for child support in the same way wages do. And unless Douglas is medically cleared to return to work, the court cannot force payments that legally and practically do not exist. It's a striking moment, because while the mother's frustration is understandable, the law here is clear. But emotions rise even higher when Miss Kirby recalls their marriage. She says she supported Douglas for years, pushed him to finish college, helped him build a career in IT, only for him to leave her once he got a good job. She feels betrayed, abandoned, and left to raise their son largely on her own. From her side, this isn't just about unpaid checks. It's about justice for the years she feels she carried him. Yet family courts are not designed to punish broken marriages. They are designed to enforce present obligations, and that tension is on full display here. Douglas, in turn, responds emotionally. He insists he loves his son deeply, that he even set aside college funds before his health collapsed. But he says the reality is grim. The disease has worsened, his vision blurs when he tries to work with computers, and at times he struggles just to get through the day. He apologizes, insists he would gladly provide more if he could, and promises that if cleared to work, he will contribute again. His sincerity seems to move the judge, who acknowledges his condition as genuine. The mother presses further, asking if Douglas can at least be ordered to cover health insurance, which she says cost her $300 a month. Again, the judge explains that unless Douglas has verifiable income, the court cannot impose such an order. The frustration is clear on Miss Kirby's face. To her, it feels like the system is protecting him while leaving her alone with the burden. But the legal principle remains. The court cannot extract money from benefits meant solely to sustain a disabled individual.